Mr. Rodhi, sorry, no oral mentioning in my court.
No, I'm not. I'm in the matter. I'm saying. I am saying.
We have no such application on board. Let it be circulated. We'll deal with it in the normal course.
But Lord, I am respectfully submitting. If
Sorry, appearing for big
today,
clients, we will not tolerate this. You have to follow the rules in my
but
court.
Lord, if your Lordship make an order today, my application will be infructuous. I am saying kindly defer the issue of grant of alpha numeric.
Mr. Rodhi, you are aware about the proceedings going on. You could have intervened at that stage. What is this after the judgment is passed? You want to intervene now?
No, Lord, the order is of 15th March.
No, but you are aware about the proceedings pending before this court.
But Lord, we were not parties anywhere. We were not parties at any time.
Everybody, the whole world knew that this matter was being heard.
Lord, I have no.
Back, one second, Mr. Rodhi. You come here after the judgment is delivered. You are now, you file an application. That's not the way.
Lord, I have come only in regard to 15th March. Kindly appreciate.
No, Mr.
I have no problem in
Rodhi,
declaration of the list of donors
Rodhi,
or the list of recipients.
Mr. Rodhi will not hear you right now. We have a specific application which is on board. You ask your advocate on record to follow the procedure. File an email. It will be dealt with by my registrar listing. We'll take a. No.
I am saying kindly. Lord,
if I do it for Mr. Rohatgi, senior counsel, then Mr. Rohatgi, you look at me. As Chief Justice, I have no face to tell all the other juniors to whom I declined list mentioning in the morning. What's sauce for the goose is sauce for the
I am
gander.
not mentioning. I am not appearing in the matter and making a submission.
We have no such application on board before us.
Lord, I have got it with me.
I've made myself.
My lord, the entire judgment has.
Second, you wait. One at a time. Sorry, Mr. Rodgi. Yes.
No, my lord, my submission is the entire judgment has been rendered behind the back of the public at large. This judgment doesn't constitute justificator. This judgment doesn't constitute justificator.
1 second.
Yes.
1 second.
This judgment is void.
Please listen to me. You are not, 1 second.
I am a citizen of this country.
1 second.
Yes.
Don't shout at me.
No, I am very soft.
Please listen to me.
Yes.
This is not a Hyde Park corner meeting, okay? You are in the court.
Yes.
You want to move an application?
No, my lord.
File an application. What I told Mr. Rodgi applies to you.
No, my lord, the question is, my lord.
There's no question you've got.
My friend has come.
Mr. Nedumbara, 1 second.
Yes.
You've got my decision as Chief Justice. We are not hearing you. If you want to file an application, move it on the email. That's the rule in this court. No further.
We will go by what your lordship.
all, please.
Whatever your lordship says, we will go by that.
Do you want another contempt notice?
No, my lord, your lordship will go by
You have
whatever
had
your
enough
lordship
submitted
says.
Bombay.
Only I have said what I wanted to say. That this judgment is rendered behind the back of the people of this country. It doesn't bind us. It doesn't constitute us. It is not a representative.
Do not,
at all.
please, once we have said no, please move the
I
application by
accept
email.
what your lordship says.
Do not continue and persist.
Yes. I only said it was not a representative proceeding.
You are
All the way coming from Kerala.
You are obstructing in the administration of justice.
Hello, my lord.
You are obstructing in the process of administration of justice.
The entire judgment is against behind the back of these people. Parliament has been rendered irrelevant.
That's all. That's all. We heard that. Please, that's all. You made it.
We are in a democracy.
We will not hear you till you follow the procedure prescribed.
My lord, we are filing it.
Please do.
We are filing it.
Please do. We'll consider it afterwards.
That's
That's
at
it.
10 o'clock. My friend came from Kerala to took a 1 o'clock flight. Be kind to us. Be kind to
That's
us.
all, please. We will not hear that.
Democracy.
Please call for the application. Please follow the application.
Democracy.
My lord, may I mention, my lord, my petition for so moto that is pending. Whatever lordship want to do, that do only. I will not disturb lordship.
Mr. Agarwal, apart from being a senior counsel, you are the president of the SCBA.
Yeah.
You should know the procedure. You have written a letter to me asking me to invoke my suo moto jurisdiction.
Yes, my lord.
No locus to mention
So
anything.
that I should not disturb
You are
lordship.
restricted with what you
We
have
should not waste the honorable time, court's time.
Fair
That's
enough.
why.
Lord,
Only that.
These are all publicity-oriented stunts. We will not permit it.
Not a handmaid of a.
Whatever lordship feel better.
Mr. Agarwala, please keep it at that. I may have to say something more, which will be perhaps a little distasteful.
My lord,
Please close it.
members of the bar who are senior to your lordship.
It is enough now.
Also senior to your
It
lordship.
is enough.
65-year-old man, Lord.
Be kind to us. We are very polite and begging with your lordship. Your lordship don't have it's a soft language.
Madhupara, we have been telling you that you are interfering, you are obstructing us.
No.
Administration.
Be said.
Now, if you don't stop, we will have to.
When we are not heard and we feel threatened. Sorry, Lord.
Follow the line.
Yes, Bala. Yes, hearing now. we issued notice on the last occasion to State Bank of India. Mr. Kapoor, you are appearing? You are appearing for
Mr. Salve is also there.
for the State Bank?
That's
State Bank?
That's right.
Yes.
But I appear for the State Bank.
Yes. Mr. Salve, in
Yes.
our order which we, in the judgment which we delivered, we had expressly asked State Bank of India to disclose all details. The language of the judgment was all details have to be disclosed. Therefore, that includes the bond numbers as well. So, let SBI not be selective in the disclosure of details. We intend to clarify that it shall disclose all details, including the bond numbers, and every part of the information which is in its possession and custody. Don't wait for an order of the court. We banked on the fact that the State Bank of India would be candid and fair to the court.
But I just, whatever your lordship say, if your lordship say bond numbers, you can disclose the bond number. There's no problem. Somebody can screen them.
Why has the SBI not disclosed?
I wanted to tell my lord how we understood your lordship's judgment. Give me 5 minutes only to explain our conduct. Well, of course, if your lordship say give anything more, everything will be given. But there's no question.
SBI's attitude appears to be: you tell us to disclose a particular detail, and we'll disclose it. That's not fair process.
How we understood.
This is the judgment of the Supreme Court. As chairman of the State Bank of India, I'm duty bound to comply with the judgment. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, State Bank of India has the best legal advice open to it.
May I not take your lordship through the 3 orders to how we understood them? My lord, your lordship's first order was 12th April 2019.
Yeah.
And we have, for convenience, my lord, we have put the 3 orders together. If your lordship just see that. We'll give everything, there's no question. Just to explain that it's not that the impression which is being created, my lord, is that State Bank of India has been playing ducks and drakes with the court. I just wanted to clear that up. If your lordship sees the 12th April 2019 order in paragraph 16, my lord, I had asked my friend to make a little compilation of the orders so we could show them easily. Your lordship has not.
Yes, para 17, right?
Para 16, my lord.
16. You got this?
Yes.
Yes.
This is the interim order my lords had been pleased to make. After my lord noting all the changes, the court would have to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same ensures adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require.
All right. Can we just see para 15 again, Ron?
Yes. The court therefore has to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same would ensure adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donation through the electoral bonds to submit to the Election Commission of India and seal cover detailed particulars of the donors against each bond. The amount of each such bond and the full particulars of the credit received against each such bond, namely the particulars of the bank account to which the amount had been credited and the date of each such credit. So, my lord, your lordships felt this would ensure transparency, that you give all this, but you keep it in a sealed cover. So, my lord, a political party doesn't need bond number. If a political party comes and says, I have received so much from so-and-so, that gives the requisite details.
We take it you're not arguing a case for a political party, right?
No. On the contrary, I'm saying the reverse. I'm so sorry, I'm saying the reverse.
But if a political,
Para 16, Mr. Salve, was relating to the political parties who had to submit the data to the
correct,
to the election commission.
correct, and they have, and this has,
No, that's a separate issue. They, whatever they have declared or not declared, that's a separate issue. But as far as the judgment of this court is concerned, because you were
yes.
also supposed to.
I'm coming in a minute. If your lordship will just give me 1 minute, how we understood it.
regional political parties, some of them have disclosed.
He is not
names of
addressing
the
your lordships, he is addressing somewhere else. Kindly hear him for some time.
Correct.
So that it comes, my lord, in the newspaper tomorrow, that Mr. Prashant Bhushan
Amazing.
vehemently said this.
Amazing.
That's the purpose.
Policy, unfortunately, public interest litigation have now become publicity interest litigation.
It is publicity interest litigation.
I
It
am
is, my lord,
pointing
there
out
are some hidden agendas. There is no doubt, my lord, and I am not, my lord, apologetic in saying.
I am astonished.
And Lord, that is the matter of, my lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately.
Lordships in your lordship's majesty
what
would
I
not
was
know,
pointing
my lord, what are the hidden agendas
This
behind
is
it.
dictated short order. I think,
just
we
point
are
out that
necessarily expanding upon the remit.
because the major political parties have not disclosed the donor.
Just give us 2 minutes to dictate the order.
Therefore, what all that I am requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a situation.
1 second, we got the point. You filed an application on that. In our order.
They have filed an
application. Mr. Ansari, just 1 moment. Do it in a very cool and calm atmosphere. It's a constitutional adjudication.
Yes,
Why should we, in our interim order, we said that the disclosure shall be made with effect from the date of the interim order,
Yes.
12th of April 2019.
Yes.
Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explain why we took that date. We said after that date, of course, the Constitution Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media, some via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rohde. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the judgment.
So the only reason why I'm saying that.
Modify that date.
No, the only reason, because your lordship asked the political parties to give donor details to the election commission prior to that interim order. And while some of the political parties have given donor details, other political parties have not given donor details. The major political parties have not given donor details. And one political party, which is in power in one of the states, says, if somebody came and left it under our door, 10 crores of electoral bonds was left under our door, we don't know who it was. So therefore, I am saying that because this is leading to a situation, though your lordship asked the political parties to disclose donor details by that interim order, only some political
Mr.
parties.
Bhushan, we have understood that argument, but what we are directing was the numbers are given, it will sort out a lot of problems. A lot of your issues will
But for that period of 2018 till April,
we are not sitting in a review.
We have taken a conscious decision.
we are faced with a situation where the
Mr. Bhushan, this will really be a substantive modification of the judgment. We can't do it like this in a miscellaneous application.
no.
And
In the light of the disclosure which has come to light of the political parties, that's why I'm saying.
And it was not a
If the
classical
political
disclosure,
parties had
it was
disclosed the donor details, this would not be required.
draw the line somewhere. We had to hold the balance. We've held the balance ultimately.
As your
as
lordship
usual.
pleases, but I just.
Can I just add one sentence? Lordship said all the details, Lordship may consider, my lord. I have pointed out that 6 details may be necessary, my lord. One is the serial number because they say 28,030 bonds have been issued. The second would be the date.
1 second. When you say serial number, you mean the alphanumeric,
Total
right?
number of bonds issued are 28,030. I'm not saying just. When a lordship said all details, my lord, in my respectful submission, it will be.
Mr. Sarve,
No, my lord, lordship, just permit me a minute.
Sarve has fairly stated that he will
No, my lord.
all the details. Why?
Yes, yes.
No, my lord, if I can just show.
And dates are all already
Consider what your
disclosed.
lordship would say, my lord. I'm just pointing out what details can be there. First is serial number. Second is the date. The third would be alphanumerical number. Fourth column would be name of the donor. Fifth column would be the name of a political party. And sixth column would be the amount. My lord, this will cover all the details, my lord, in my respectful submission.
My lord, this is now asking us to sit down and collate one.
This
with
is a
the other.
commission made to the court. Just like Mr. Salve made a submission to the court. I'm making.
Yeah, we need.
Very well. I'm making a submission to the court. Mr. Salve
No.
asking us to do whatever. Look,
Please permit my lord, the Chief Justice to dictate the order now at least.
Secondly, my lord, the lordship said, lordship has seen that IA, my lord, I filed that IA. For a preview, if a lordship have taken a conscious decision on that aspect of the matter, my lord, lordship may say, my lord, because the order said, my lord, the voters are entitled to know as a right of information. If a lordship have taken a conscious decision on that matter, my lord, it will be from 12th of April only, because we said, my lord, it should be, my lord. Otherwise, logically, once the right to know, my lord, is inbuilt in the system, in right to know of the voter, then very well, I'll leave it at that.
And there is a specific direction with effect from 12th April.
Then your lordship said, I have not pressed the
So
application.
Bhujan, there will be no end to it.
IA, what is the IA number, Mr. Ansaria? Just 1 second, Mr. Bhujan. IA number which you are not pressing is IA number?
Diary number 12580-2024, which is MA number, MA diary number.
So that you are not pressing.
Yes, my lord.
Just
Just
one,
say it. MA
by way
diary
of
number
information only.
580-2024. Mr. Vijay Hansaria, learned senior counsel appearing on behalf of the applicant, states after some submissions at the bar that the miscellaneous application is not pressed.
In view of,
one
my lord,
thing.
whatever proceedings have gone to the court, in view of the
In view, we'll say, in view of the specific directions contained in paragraph 200, in paragraph 219, bracket B and C of the judgment of this court dated 15 February 2024.
Just one fact by way of information.
Enough of assistance by this public spirited person, my lord.
The details-
Your lordship doesn't need any further assistance.
The details of the number of bonds shown by the, in the data. which
He is
has been
gathering the
submitted.
details for a future PIL, my lord, so that
number of bonds-
remains in,
the
he remains
number of-
relevant.
Now, please permit the my lord, the Chief Justice to dictate the order.
Heard everybody, Mr.
I was just pointing out that there is a huge mismatch between the number of bonds purchased and the number of bonds encashed in the data submitted by the State Bank to the Election Commission. They are showing 18,871 bonds purchased, but showing 20,421 bonds redeemed. The total amount of bonds purchased is 12,155 crores, and the amount redeemed is 12,769 crores, that is 550 crores more than what were purchased. Now, the explanation for this could be because the data is from 12th April. At that time, the bond purchase was going on. On 12th April 2019, it was going on. What is possible is that some of these bonds were purchased prior to 12th April 2019, but redeemed after 12th April 2019, and that is why there is a mismatch. But I just wanted to point out there is a very large mismatch.
There is no, my lord, these figures are not authentic. I've given the authentic.
18,000 versus
Roughly
20,000.
Sponsored NGOs are, my lord, fudging the figures and bringing their own, my lord, your lordships are aware, there is a beautiful, my lord, quotation by Einstein, that some people use statistics like a drunken man uses lamp posts more for support than for illumination.
I'm just showing the number. I'm saying that 18,000.
And this is what happens
Okay,
when
now
it,
leave it at that. I will.
My lord, those numbers are not right. Since, my lord, because all this is going to play out, the numbers are not right. The corrected numbers were not given in our application.
वो अलग order pass कर देंगे. इसमें MA में ऐसा लिख लीजिए. In subpara B and C of paragraph 221 of the judgment of this court dated 15 February 2024, the direction to the SBI to submit details of bracket 1, the electoral bonds purchased, semicolon, and bracket T2, political parties which have received contributions through electoral bonds is specifically since the date of the interim order dated 12 April 2019. Stop. In other words, all details which have been directed to be furnished in the operative directions of this court are with reference to the interim order, are on the basis, don't say on the basis of, are with effect from the date of the interim order, namely 12 April 2019. Full stop. The relief which has been sought in the MA for predating the point of disclosure would amount to a substantive modification of the judgment and hence cannot be dealt with in a miscellaneous application. Full stop. The misdirection of the application is therefore not maintainable and is accordingly dismissed.
But I want one more relief to prevent another round of contempt proceedings. Would your lordship just for a minute have my affidavit in compliance for it?
What is it that you want clarification?
Yes. Maharaj, there was, when we gave your lordship, that's why I can see all this story has started. When we gave your lordship the original figure of 22,217 bonds, we had, by mistake, that was from 1st of April, not on 12th of April. If your lordship just sees para 4 and Maharaj, everything will be over because I know where this is going, where Mr. Bhushan is going. Please see para 4 of my compliance affidavit for 1 second. Maharaj.
Yes.
And please, I would invite your lordship to say, your lordships accept this. We have given the figures, Maharaj. There is no mismatch, there is nothing of the sort. The total, if your lordship sees the table.
I'm not going to all that. I mean,
I have to convince my lord I have complied with the order. I'm just saying.
It's a compliance affidavit. It's a compliance affidavit of your chairman and managing director. We have accepted that.
Please say your lordships have accepted our compliance affidavit. That will put an end to all this.
By the judgment of this court dated 15 February 2024, this court directed, into inverted commas, this court directed, into inverted commas, the disclosure of information on contributions received by political parties under the electoral bond scheme to give logical and complete effect, into inverted commas, complete, to the ruling. Full stop. Thereafter, in paragraph 219, this court issued operative directions. These directions in subparagraph B and C are in two parts. Full stop. Subpara B requires SBI to submit details of the electoral bonds purchased since the interim order dated 12 April 2019, into inverted commas, till date to the ECI, into inverted commas, complete. Such details, the court has indicated, into inverted commas, shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased, into inverted commas, complete. In the second part of the operative direction, in subpara C, SBI was required to submit, into inverted commas, the details of political parties which have received contributions through electoral bonds, into inverted commas, complete, since the interim order dated 12 April 2019, till date to ECI. Full stop. SBI was required to disclose details of each, underline each electoral bond encashed by political parties, and to include, inclusive of the date of encashment and the denomination of the electoral bond. Full stop. The above narration and a plain reading of paragraph 219 of the judgment dated 15 February 2024 indicates that SBI was required to submit all details, both in terms of the purchase and in terms of the receipt of contributions. Full stop. The expression, to invert commas, include in both subparagraphs B and C clearly demonstrate that the inclusive part was regarded as illustrative and not exhaustive of the nature of the disclosure which was to be made by SBI. Full stop. In other words, we now, there's no manner of doubt that SBI is required to make a complete disclosure of all details in its possession. Full stop. This, we clarify, will include would comprehend the alphanumeric number of, and the serial number, if any, of the bonds which were purchased and redeemed. Full stop. The application, this was on your application, I think you had moved this, no? The application was by Oh, yeah, we had. Therefore, Mr. Harishan Salve, Learned Senior Counsel, states that there is no reservation on the part of SBI in disclosing all details which are in its possession and custody. Full stop. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date Daldo.
Could we have one more day, one Thursday?
Stating, yes, that's certainly 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop.
This will be given to the Election Commission.
In terms of the directions contained in paragraph 221.
Your Lordship may indicate the date when it will be uploaded by the Election Commission.
The Election Commission shall upload the details forthwith on the communication by SBI.
My Lord, I had directed my Lord the senior official of the bank to remain present. My Lord, the deputy managing director and chief general manager are present here. The presence may be. They both are here.
Applicant is in jail since more than 6 years. Considering aforesaid circumstance, application is allowed. Applicant be released on bail. Now, इसमें कितना दिया है? 50,000. 50,000 कर देना. One permanent resident of 5 lakhs किया. Personal bond of 5 lakhs with 2 local solvent sureties of the like amount. Same कर देना इसमें.
They were appear for the trial court regularly.
Applicant will regularly appear before the trial court and will not seek unnecessary adjournments in trial.
Sir,
dismissed.
This case.
आप आ ही नहीं रहे हैं सालों से उसमें. ये 3 बार तो हमने डेट लिखाई है उसमें. Yes, next.
Lordship.
You may file fresh.
Lordship, last date पे इसमें criminal record इन्होंने मंगवाया था.
Yes.
This is first bail application.
साकिब अंसारी का criminal record नहीं है.
Lordship.
But connectivity जो है.
Yes.
ये पूरे लेन देन के बीच में इसके द्वारा जो है पूरा
कितना लेन देन है?
ये 51,000 के एक्चुअल में इसमें नौकरी लगवाने के नाम पर जो है इनके द्वारा ये आपको वर्क टू होम पे काम करने के लिए जो है से पार्ट टू पार्ट में पैसे लिए वर्षा द्विवेदी का मैं स्टेटमेंट पढ़ देता हूँ मतलब। पूछताछ में बताया कि वीटी कॉलेज में बीटेक फाइनल की पढ़ाई कर रहे हैं 17/9/2023 को मोबाइल नंबर स्वयं व्हाट्सएप पर मोबाइल से एक मैसेज आया जो फॉर्म वर्क फ्रॉम होम के लिए जॉब ऑफर किया था, जिसने कंपनी का कंसाइनमेंट आईडी बताया था, जिसने कंपनी का पता विपड़ी नगर पुणे बताया था। कंपनी के द्वारा 300 रुपये प्रति पेज टाइपिंग का काम बताया था, जिसने कंपनी द्वारा रजिस्ट्रेशन, मेरा आधार कार्ड, नाम, परिवार की जानकारी, मोबाइल मांगा था। जो
आपको तो बेल नहीं देंगे
लॉर्डशिप, मेरा निवेदन सुन लें।
कभी कहीं बंगाल से, कहीं हल्द्वानी
लॉर्डशिप, मेरा
उत्तराखंड से फोन कर करके आप लोग चीटिंग कर रहे हैं।
मेरा निवेदन लॉर्डशिप सुन लें। इसमें मेरा ऊपर ऐसा कोई एलिगेशन नहीं है। ये रिहांस 3 लोगों पे, मैं कंपनी का एम्प्लॉय नहीं हूँ, 3 लोगों पर एलिगेशन आया जिन्होंने ये किया, उनको अरेस्ट कर लिया गया। मुझे तो मेमोरेंडम में बनाया गया केवल इस बेस पर, और मेरे ये जितने भी अकाउंट्स नंबर हैं इनमें किसी में मेरा नाम नहीं है, ना ही मेरे ट्रांसैक्शन।
फाइनली 400
लॉर्डशिप, इसमें एक चीज
वेरी डिफिकल्ट टू ट्रेस।
लॉर्डशिप, ये जिस
इट हैज टू बी डेल्ट विद स्ट्रिक्टली। टाइम आ गया है, हर दूसरे दिन ये कंप्लेंट्स आ रही है, फोन कर देते हैं मोबाइल पे, साहब आपका बैंक अकाउंट है।
हमने नहीं किया, उनकी जो कंप्लेन है वो 3 लोगों के खिलाफ है।
ये स्टेट इनका क्या
मेमोरेंडम में हमको
इनका मेमोरेंडम भी है और स्पष्ट ये आया है इनका कि